once a general contractor receives payment from the owner, they have 7 days to pay the subs. If they miss that payment timeline, then interest can begin to accrue. And then if a GC or an owner receives an invoice for materials, they have 35 days to pay that. On the 36th day, interest begins to accrue. And so this interest will begin to accrue whether you send a demand letter or not. And so, and in Texas, what the penalty is 1.5% per month or 18% per annum. That's the same for each month that you remain unpaid. Normally, you have to have a signed contract to charge interest. So this is a way for you to get it by law. All right, guys, it's Karalynn, and welcome back to the podcast where we talk about construction legal made easy. And so today I have a topic which is prompt payment, and specifically for Texas. So let's talk about the idea of prompt payment generally. What does that mean? Okay, so most states have incorporated what's called a prompt payment law. And what that means is that there is a requirement when the general contractor gets paid, he's got a certain timeline to pay the subs. And when the subs get paid, they have a certain timeline to pay their subs and material suppliers. And if they don't timely pay, there's an interest penalty, right? And so generally, under the laws of contract, you're not entitled to charge interest unless you have a contract in writing. And what this law says is that even if you don't have a contract that calls for interest, that you can charge interest if you're paid late. So let's dive in. Specifically in Texas, the prompt payment laws are contained in Chapter 28 of the Texas Property Code. And what it says specifically is that once a general contractor receives payment from the owner, they have 7 days to pay the subs, right? If they miss that payment timeline, then interest can begin to accrue, right? And then if a GC or an owner receives an invoice for materials, they have 35 days to pay that. On the 36th day, interest begins to accrue. And so this interest will begin to accrue whether you send a demand letter or not. And so, and in Texas, what the penalty is 1.5% per month or 18% per annum. That's the same number for each month that you remain unpaid, right? And so, like I said, normally you have to have a signed contract to charge interest. And so this is a way for you to get it by law. And how it usually works out is that if you're unpaid, you file a lien, you can add your interest claim to that, right? Obviously, there are some exceptions to this prompt payment. The general contractor has the right to withhold your payment if they dispute your work, or if you have defective, or if they're claiming defective work, right? If they think the work that you did was not good, they can withhold up to 150% of what you're owed, which gets them out of they won't owe interest for that time of holding the funds, right? But it does set you up for charging interest when you're not paid on time, right? And so in Texas, actually, there is a specific rule in Chapter 28 that will allow you to stop working if you're not paid and the owner has already paid the general. So generally, you have a pay when paid clause in your contract, which states that you have no right to payment until the owner pays the general, right? When that happens, and the general's got 7 days to pay you. But the law provides that if the owner has paid the general and the general hasn't paid you, you can send a letter letting them know you're going to stop working, right? And so the letter is, I've submitted my pay application. I know you've gotten paid. You've either verified with the owner or done a public information request to know that the general contractor has gotten paid, and they still haven't paid you. At which point you can send out a notice that says, hey, if I know you've been paid. If you haven't paid me, you need to pay me now, or I'm going to stop working in 10 days, which is actually a great remedy, because normally under a commercial subcontract, you do not have that remedy. I actually had this just work out on a project for a client. The client was doing some remodel work at the airport, and it had been months since they had been paid. So we're talking January or February. They hadn't been paid since then, and it's now May. And so they kept getting promises of payment, did not receive payment. They had thought that the general contractor had been paid, but didn't know for sure. So we did a public information request and found out that in fact the general contractor had been paid but had failed to pay my client. And so we sent this 10-day notice demand letter saying, hey, I know you've been paid. You still haven't paid us. Pay me the 50 grand I'm owed or I'm not coming back to work. And here's your 10-day notice. Client got paid. So it is a very effective remedy. You got to use it wisely. I would highly recommend having an attorney research and send that letter. If you do it wrong, you could be in breach of contract and actually be worse off. So it's something that is available if you're not paid on time, but it has to be done properly and documented properly, which is a great remedy to have because normally you don't have that under a commercial subcontract. So this also does apply to public works projects. It applies to private projects, commercial projects, all different types. Like I said, several other states have similar laws, not exactly the same as Texas. We'll take some time to dive in those next, but just a little soundbite on how in Texas you can accrue interest on outstanding amounts.